So this is for a short sale. My question is, why would any lender give up their deficiency rights if not required to by law? You're saying that some lenders have these letters at closing and some don't. It would seem to me that all lenders would retain those rights.
It would seem, I mean, I agree with you entirely that that if I have my lender hat on, I'm not going to waive my deficiency right or my future collection right if I wouldn't have to do so following a foreclosure. But I will tell you that I am reviewing on about a weekly basis short sale documents where the seconds are waiving their collection rights. I don't have an explanation for it because it's usually for a very nominal payment.
What about the primary though?
The first?
The first, yeah.
Well, that was the circumstance I was trying to describe earlier, that it used to be that you could pretty much assure that on a primary residence that they would go ahead and waive any deficiency rights because they wouldn't have that right if the person told them to. I call it pound sand. Pound sand, you can take it in foreclosure. But there has been examples in recent weeks where I've seen it a couple different times now where the first on a primary residence absolutely will not waive deficiency rights.
Tammy, so on a judicial foreclosure, I'm sorry, I'm going to ask a question. I got the microphone. But this is back to your question, Jack. So if there's a judicial foreclosure, then does the homeowner have a 6-month right of redemption period? And then does that mean that the bank basically has to inventory all these foreclosed properties for 6 months before they can turn around and sell them?
Yeah, in terms of redemption rights following a judicial foreclosure, a borrower or the judgment debtor has 180 days to redeem the property, which they accomplish by paying the amount that was paid at the sheriff's sale, plus accrued interest, and including some costs. So if a lender has gone in, for example, and winterized the property or paid electric bills, those can also be included in the redemption amount. There are no redemption rights following a trustee's sale, except for the IRS. The IRS has 120 days to redeem following a trustee's sale. So to answer your question, yes, they have to inventory and hold it for that period of time. There are some limited circumstances where they could possibly obtain a waiver of the redemption rights, but it is not as straightforward as just having somebody sign one piece of a paper and a waiver. It's more complicated than that.
So I'm thinking, Jack, and I'm not the attorney, that sometimes they just don't want to do that. They don't want to hold the properties and wait 6 months. It's just better to get it over with on a trustee sale and turn around and sell the property. That goes against this whole idea of shadow inventory, but that's a whole other conversation.
Do deficiency rights exist on a non-owner occupied property if the deed or the note has what's called a power of sale clause?
Yes, the power of sale clause just provides the lender with the right to use the non